I'd like to call the Board of Appeals into session. Today is March 8th, 2017. I'd also like to recognize Frank Johnson, who is the attorney for the Board of Appeals and will be sitting in on the first two cases before us this evening.
Thank you.
The first on our agenda is the special exception review. It is a biennial review. This is case A351, and that would be 16. Innes Reed, 109 South Summit Avenue. It's R90, medium density residential zoning. It is the biennial review of the rooming house. And I would like to ask Caroline, would you like to present the official record?
Sure. This is a biennial review of special exception A351, and it's the review number 16. No public hearing is required for this special exception. It's just a review. The petition requests a biennial review and extension of a special exception granted on May 5th, 1988, allowing a rooming house for 5 roomers in the R90 medium-density residential zone as permitted by Section 24-29(3) of the City of Gaithersburg zoning ordinance, Chapter 24 of the City Code, at 109 South Summit Avenue, Gaithersburg, Maryland. And they're not official exhibits because it's just a review, but there are several things in your package, a letter from Mrs. Reed requesting the review, and also a memo from Neighborhood Services Director Kevin Roman indicating that the rooming house has been inspected and is up on all of its code compliance. Inspection was done in late February. Mrs. Reed is here if you have any questions for her, but otherwise the resolution has the same set of conditions that have been carried forward for many years now, and none of those have changed.
Okay, thank you very much. Mrs.
Good
Reed,
evening.
Good evening. May I go ahead and swear you in as a witness? And if you want to go ahead and raise your right hand and say, do you solemnly swear and affirm under the penalties of perjury that the testimony you are about to give in this matter shall be the truth and nothing but the truth?
Yes.
Yes,
it's
thank
true.
you. Please proceed.
My name is Innes Reed, and I do have a rooming house on 109, and we had the inspection, and it was great. We had a very nice inspectors, and we had the fire inspector too, and that's all I can say. I'm running the rooming house for many years.
Okay, thank you, Mrs. Reed. Do we have any questions from the board?
My only question is, and I'm not sure if this is for Frank or Caroline, in the current 10 conditions, there was the notice from Kevin Roman about installing carbon monoxide detectors. Is that included now within those 10?
It is included now. We put 2 or 3 because that day we didn't have it, but we set it up.
Right, so I assume then that's in those conditions that discuss
Yes,
the
it is
housing
there.
requirements, that's one of
Right.
Yeah.
those. It just carries into
Right.
it.
Mhm.
Okay.
Yes.
Any other questions?
Nope, I'm good, thank you.
Okay. All right. Now we will have any other further discussion or review of the draft resolution that is in front of you.
I think I'm okay with it.
You okay? Okay. All right, so can I call for a motion then for the application and the resolution?
I'll make
For
a
approval.
motion that we approve the resolution as stated with the 10 guidelines.
Okay.
Second?
Do I need to read the whole, should I read the whole?
Should we put the case number in there?
Yeah.
Yeah, so go
Yeah.
ahead. Do you need the case number?
I got it right here.
Okay.
So now therefore be it resolved by the Board of Appeals of the City of Gaithersburg on the 8th day of March 2017 that case A-351, the petition of Inez Reed requesting an extension of a special exception for a rooming house in the R90 medium-density residential zone at 109 South Summit Avenue be approved, subject to the applicant complying with the following 10 conditions.
And can we have the second again?
Second.
Second.
Okay, all right. All those, any further questions? Okay, all those in favor?
Aye.
Opposed? Okay, the motion, the resolution passes 5-0. Thank you. Thank you, Mrs. Reed.
Thank you very much.
Thank you. All right, next, okay. Next on our agenda is a public hearing, and this is for Board of Appeals, case 7516-2017. It is with Ms. Cesarini Camden of 533 Summit Hall Road. This is an RP-T, a medium-density residential zone, and this is for a special exception for a child care facility. Caroline, would you like to present
Sure.
the case?
This is public hearing on Board of Appeals case BOA 7516-2017. The hearing was published in accordance with the requirements of the city charter and code on the city's website, and the property was properly posted. At the present time, there are 13 exhibits in the record files. They are referenced in an exhibit list in the files. The individual exhibits may be reviewed during the course of the meeting or in the Planning and Code Administration Office during regular business hours at City Hall or on the city's website. Any objections to the receipt of any exhibit should be noted prior to the closing of the record, otherwise they will be deemed received in evidence. The application requests a special exception to permit a child daycare facility for up to 8 children at 533 Summit Hall Road, Gaithersburg, Maryland. Property is located in the RPT, medium density residential zone. Special exception is allowed by section 24-43A1 of the City of Gaithersburg zoning ordinance, chapter 24 of the city code, subject to the review of the Board of Appeals. And just to orient everybody to the site, these are a series of townhouses. Ms. Camden's townhouse is the one right here, third from the left, off of West Deer Park Road, and this is Summit Hall Elementary School and Summit Hall Road here. And there is information in the record regarding a fire inspection that was done on the property that was passed, and photographs of the house and a layout, and also approval from the condominium association for the use. And Ms. Camden is here, and I'll let her introduce herself and what she's looking to have approved.
Well, thank you, Ms. Camden. I need to swear you in, so if I can ask you to raise your right hand. Do you solemnly swear and affirm under the penalties of perjury that the testimony you are about to give in this matter shall be the truth and nothing but the truth?
Yes.
Thank you. Please proceed.
Good evening. My name is Cesarini Camden, and I would like to use my house for daycare. And I went to fire marshal inspection. We have everything inspected and they approve it. And I asked the condo facility, condo management.
Can I ask you just to pull the mic a little closer to you? That's okay. Thank you.
And I see I asked the condo management, and they also approve it. And we have the parking space, but we have only one car. We have 2 spaces. But during the hour of operation, my husband will not really be home because he'll be on his daily duty. That means we have like a 2 parking spaces available almost most of the time for the daycare.
Okay. All right. Do you have any other thoughts? We can open it up for questions to the board.
Done.
Do you have any questions here?
I think she touched on, when we've had some of these cases come before, about the parking is the main, object of these things, because at certain times, I don't know if you have 8, people come in at once to, pick up their kids, and you're gonna be by yourself, or do you have other workers?
Now by myself.
Okay, because that's the only issue that I think we've ever, brought up is, where do people park if all 8 come at one time? You don't want to be blocking, because I know parking, I've lived in these homeowner associations before, it's tough, parking at certain times, because not everybody abides by the, number of spaces they have.
Do you want to point out where
Yes.
your spaces
We
are?
have a visitor parking
Is
around.
it here?
Yes, we have a visitor parking.
Are these all visitor parking?
No, maybe two,
Some.
we got two visitor parking.
Two?
Yes, that area.
And then you have spaces
Yes.
here.
Yes. Usually during the open, the hour, most people are not, it's like, it's empty. My two parking spaces will be
Empty
always
during the day.
empty.
I did pull up aerials going back several years of this site, and I don't know what day of the week they each are, but they all kind of pull up looking like this, with a lot of empty spaces.
I can ask a question with respect to actually the record. So what we're seeing here is exhibit number, well, I guess it would be exhibit number 6 is the same picture.
Yeah,
But it looks like what we're circling is a townhouse.
yes.
But the picture in exhibit 3 looks like it's detached or semi-detached. So are we looking at the right
You know, let me
house
pull-
in
let
both
me-
pictures?
I don't know what, let me pull up. Hold on a
And the
minute.
picture in exhibit 3 has parking right in front of the front door, which isn't the case in the aerial of the townhouse that was circled.
Let me pull that up. Four, seven.
There's a 555.
You talking about this?
Yeah.
On the
So
door, it says
Can you
550.
explain where is this
Oh,
parking?
on the
this is, this one faces my house. My parking is like, I don't know.
Oh, okay. So the one that's circled is the correct one in the aerial, but the one that's being shown in exhibit,
That's my, at that point, it's a picture of the parking with
Uh-huh.
the house that faces my house.
got it. Okay,
Okay,
It's like the
That makes a
end
lot more
of the
sense now.
toilet.
thank
so
you.
it's, in other words, over
Yes, and
over
the
here.
unit, yes, the
Okay.
end unit.
Okay. Thank you.
Right.
And then I have another question for you, and may not necessarily even be in the purview of this body, but in exhibit 4, the inspection checklist, it says areas off limits, and it says basement and second floor. How are you going to make sure that those are off limits for the daycare?
No, I have this gate, and the basement got a door,
Uh-huh.
it's locked, and I also have a safety knob, like the kids cannot open it.
Yep.
I have it there already.
Okay.
And the stair, I have a gate that the kids cannot go there. And like in area that the kids will not go there, I have a gate.
Great. Okay. Thank you.
So the kids will not cross the area.
Okay, any other questions? Okay, I don't have any questions either. Okay. Is there any other testimony from, any additional testimony from other parties here this evening? Okay. I'll need a motion to close the record.
I move that we close the record on case BOA 7516-2017.
Second.
All those in favor, say aye.
Aye.
Vote passes 5-0. Okay, and then we need to take a discussion now and review of the draft resolution that's in front of you. All right. Is there any questions on the conditions that we have for this special exception?
No, I think they follow the guidance of the planning commission.
Okay. All right, well, if there's no further discussion, can I get a motion to approve this application? And with application and resolution?
Sure. I make a motion that the Board of Appeals, based on the findings and conclusions outlined in the draft resolution, approve special exception application BOA 7516-2017 for a child daycare facility for up to 8 children at 533 Summit Hall Road and adopt Resolution BOA 7516-2017 with the conditions as presented.
Can I get a second?
Second?
All those in favor say aye.
Aye.
Opposed? Okay, the motion passes 5-0. All
Thank
right,
you.
thank you very much. All right, we're now going to move to our third item on the agenda. Just give me a minute to get organized here. Please, have a seat. All right, this is a. Good evening. Good evening. I'd like to announce this is Board of Appeals 7462-2016. This is the continuation of the administrative review for 1 Thorburn Road. I'd also like to recognize Alyssa Levin, who will be serving as the attorney for the administrative review for the Board of Appeals.
Good evening.
Thank you. At this time, I'd like to recognize Ron Emmert, who has a statement to make.
Madam Chairwoman, I am recusing myself from this administrative review for personal reasons.
Thank you. Okay. Also, I'd like to ask a board member to read the notice of the executive session.
Take care of that.
Thank you.
A closed executive session was held at 31 South Summit Avenue, Gaithersburg, Maryland, 20877 by the Board of Appeals on Wednesday, February 8th, 2017 at approximately 10 p.m. pursuant to a motion adopted unanimously. The session was closed pursuant to Section 3-305 sub B sub 7 of the General Provisions article of the Annotated Code of Maryland to consult with counsel to obtain legal advice. The topic discussed was legal counsel regarding the administrative review under review. Present at the session were all members of the Board of Appeals, members Reed, Kotok, Chiswell, Emmert, and Young. Staff present were Caroline Seiden, Kirk Eby, and Alyssa Levin, the BOA attorney. Upon conclusion of the discussion, the closed meeting was adjourned at approximately 10:30 p.m.
Okay, thank you very much. Okay. We have received some information, and Mr. Rosenzweig has requested additional time, and the city attorney has objected to the request. Does anyone on the board want to make a motion that would ask, wants to make a motion to allow the closing statement as requested by Mr. Rosenzweig?
I move that we permit the closing statement as requested by Petitioner Rosenzweig.
Do we have a second?
Second?
Okay. We'll take the vote. All those in favor?
Aye.
Okay. All right, so, Mr. Rosenzweig, we do have, you were sworn in last time, so that carries forward. If not, I'll be notified. So, I understand you'd like to make a closing statement, and I would like to limit the closing statement to 5 minutes. Is that good?
I timed myself, it was around 6.5 minutes.
Okay, so let's keep it at 7 minutes,
Yeah.
and we'll also time it here, and then the city attorney will also be able to respond also for
Okay.
7 minutes.
Okay.
Please, go forward.
I built a fence in 2014 because the city asked me to. I involved my next door neighbors in the process. I strive to do it well and do it right the first time. I went to the city planners and asked for advice. I did what they said. I hired a licensed survey, a boundary marker surveyor. I built the fence. The city inspected it. The city gave final approval. Final is supposed to be final. When I built my fence, my neighbor did not protest. He lived there for 1.5 years with the fence and never had an issue getting into and out of his driveway, and never had an accident. My current neighbor purchased that home very recently, but long after my fence was erected. He then proceeded to immediately assume I had no permit and filed a complaint with the city. He never once discussed any of this with me. The simple solution is to install convex safety mirrors, either on my fence or nearby, if it would help Mr. Jaramafar. There are reasonable ways to mitigate his concern which don't require moving the fence. Much of the city's testimony deals with the 14-foot distance from my home that is shown on the drawing because they are ignoring the actual metal stakes that separate my property from the city's right-of-way. In both versions of the drawing the city has on file, the distance is 14 foot from my house. While filing the permit, we asked if we should modify the distance on the second drawing, and we were verbally told it didn't matter, and it wasn't exact. What mattered was the distance from the road. Today, the city lawyer asked if I was surprised that the fence is longer than 14 feet from the foundation of my house. Of course I'm not surprised. I couldn't make the numbers work when I submitted the drawing, and I was told that's because it wasn't to be used for that purpose. Just a general idea of the layout, of what we wanted to do. We were assured everything would be okay as long as we stayed within our property lines. We hired the licensed surveyor who laid both metal and wooden markers in the ground and connected them by string. The city came out and found it all looked good in 2014. We received final approval. Today, the city purposely ignores the important letter submitted as part of my original permit application, which clearly states the fence will be built 11 feet from the curbside, which was permitted, approved, and passed final inspection. Today, 2 years later, different inspectors are looking at the drawing and finding fault. They note that the drawing doesn't show the 12-foot right-of-way. I admit to not understanding this in 2014, but that is only because the city staff who helped me didn't understand it either. It doesn't change the fact that I put a good faith effort into this project and adhered to all that I was instructed to do in 2014. It's not right for the city to behave differently today because I came and asked for advice on how to do this right. The citizen pays the permitting fee and has a reasonable expectation to rely on the expertise of the city planners to complete the project and obtain final approval. It's not right for the city to act differently years down the road by revoking that approval. That means final approval is never final. How many citizens will suddenly be targeted now, all with projects that were deemed final, if you side with the city in this case? If there was a time to move the fence, it was in 2014 when the city inspected and granted final approval. Not now, not 2 years later. The metal boundary markers don't lie. I'm not 2.5 feet into the right-of-way. I'm not even in the right-of-way. My fence is completely within my property lines. I'm allowed to build the fence in the public utility easement, which is still my property so long as I have a permit, which I received in 2014. The public utility easement is not the right-of-way. We must have faith that the inspector in 2014 knew what he was doing. He is still on the payroll, and there is no evidence that he cannot do his job properly. Don't you think the inspector in 2014 would have known if I was in the right-of-way? He could clearly see what my licensed boundary surveyor outlined. It made it easy to see in 2014. I shouldn't have to keep hiring surveyors to come out every time the city gets confused. The city shouldn't have to keep re-inspecting projects that have already passed final approval. Why is the city on a mission to find mistakes years down the road? The inspector in 2014 knew how to measure from the curb, just like the similar fence also on the same Redding Ridge Road in my community. He granted final approval in 2014 because I did what I was supposed to do. At the hearing, city staff still can't get their facts straight. Before suggesting we revoke the final approval, they should double and triple check their numbers. The Permit and Inspection Division Chief, Wes Burnett, said at the hearing he would need to come out and measure a fourth time because he still is not sure. The city lawyer tried to say the fence should be 33 feet from the curb, which was clearly wrong. Only after I brought up this terrible mistake did she confess the number was incorrect. What if this was a multi-million-dollar apartment building? 2 years later, will the city say the building should be moved and refuse to say where to move it to? Why is my family treated any different? For me, this is a lot of money, and I did it with the best of intentions. It was unreasonable for the city to ask me to build the fence in 2014, but I did it anyway, to the best of my ability, and received that final approval. Today, city staff refused to paint on the ground to let me know where they'd like me to move the fence. If they don't paint, how can I know? How can I have any faith that they won't come out and tell me it is wrong again? How can they be certain the fence is placed improperly if they aren't able to draw a line in the dirt? If the city does not know where the fence should be, how can they determine where it should not be? When I asked if the city would pay to move the fence, staff laughed at me and said, "That's not going to happen." How is this funny? How can anyone find humor in this situation? I have zero confidence in the city staff at this point. It feels like they're going to use this flawed design drawing and habitually find new ways to tell me to move the fence. Please stand up for me and tell the city how absurd all of this is. Why is so much time and effort wasted in this endeavor? Does it even make sense to spend taxpayer money for city staff to continuously revisit permits that have already passed final inspection? It has no merit. If you invalidate my fence permit by revoking the final approval, you are encouraging abuse of power and diminishing citizens' expectations of fair treatment. Final should mean final. Thank you.
Thank you, Mr. Rosenwhite. Ms. Board?
Sorry. Thank you, excuse me, members of the Board of Appeals, and I'll be very brief because I do believe we covered most of these issues at the time that we did our prior closing statement. As I pointed out to this board previously, Mr. Rosenzweig has the burden of proof in this case, and he simply has not met it. Based on the closing statement he just provided, he seems to try to shift all of the responsibility and liability onto the city. He's the one who submitted the plans. He's the one who submitted drawings. The city's planning staff does not have the practice or the obligation of redesigning drawings on behalf of applicants. We don't do that for commercial applicants. We don't do it for fence applicants. We can only review those plans that are submitted. And clearly the plan is the controlling document. As we showed at the hearing, the plan shows the fence dimension on that one side as 14 feet. It also shows the fence as being completely out of not only the public right-of-way, but also the public utility easement. Certainly the fence that is constructed does not meet either of those requirements. Mr. Rosenzweig talks about the 2-year process being burdensome. You know, does the city wish the inspector had not made a mistake when it went out 2 years ago? Absolutely, we do. But however, there's no further burden on Mr. Rosenzweig of moving the fence today than there would have been moving the fence 2 years ago. So we don't find that to be a persuasive argument. I mean, the bottom line here is the city had a complaint. We have an obligation under our ordinances to investigate complaints. As part of that investigation, you know, certainly the complainant provided you testimony as to how the fence is impeding his sight distance and coming to and from his house. The document that you had in evidence from Mr. Mumpower, the city's traffic engineer, saying that there were no sight distance problems was based on the plan that was submitted. This was not a subsequent review of the fence in an as-built condition. So certainly there is an issue here. We have a complaint that we need to address. The city is well within its responsibility, and in fact, it does have an obligation to go out and investigate complaints and correct errors. So clearly in this case, the applicant has not met its burden of proof, and we would respectfully request this board to deny the administrative appeal. Thank you.
Thank you. Okay, and now I'm going to ask our counsel, Ms. Levin, that I just want to verify that we did close the record, and would there be any reason to close it again based on this testimony?
No, there's no reason to take any further action.
Okay, thank you. Okay, so now this part of the meeting is where the board will discuss the case. I'll open it up for discussion.
I guess you can start.
All right, I've gone over a lot of this paperwork, you know, a few times, and I know a lot of the testimony's been brought up, and if I feel like if everybody feels like I'm rehashing it, but it's just trying to get everything straight. But the one thing I did find out, you know, there's 3 people in error here, but what I'm trying to figure out from the initial plans, it said the estimated cost was $7,000, and then I saw that it ended up being $8,000 instead of, you said you got one estimate for, I think, $12,000 or whatever. Am I assuming wrong maybe that when they built it at the original 14 feet, the contractor and you, because I see you come across as a very intelligent individual, and that maybe they said at 14 feet that just doesn't look right. Could that be maybe where that extra $7,000 to $8,000 came in? And, you know, and I can see where at 14 feet it could be approved, because I went and parked in his driveway and I backed out. It's very hard to see cars coming around the corner. But I'm just wondering with the contractor, you know, might have come up and said, this doesn't look right, because too much land left over in the yard, and say it would look better down there. So that's the only problem I have, is seeing where this discrepancy between the 14 and the, was it 31, 32 feet, the way it ended up, how it took place.
You want me to respond, or?
No, that
Or-
would
or
not.
I was just making
The
comments.
record is
Yeah,
closed.
No,
I
the
was just
record
making
is
comments.
closed.
The record is closed, so. Okay. Aaron?
I mean, it seems to me that in this conversation where it's an appeal, it's a petition for administrative review, and the question here is, was there an error in the official notice to correct violations? So that ultimately boils down to, is the fence within the right-of-way or not? Lots of issues have been brought up, lots are valid, lots of I think are worthy of conversation and remedy at some point. But if what we are asked to review is that question, was the notice in error? And is the question of whether the fence is in the right-of-way, then that is the one thing we should be focusing on. I think the evidence has shown that the fence actually is in the right-of-way, and that we should deny the petition.
Thank you.
Well, I like Robert and everybody else that, it's a tough situation for a neighborhood. But I do think, the issue is it a safety issue or concern for your neighbor and his guests? And I think that's a valid concern that he has. It's not only him, but it's anybody who visits him who's not used to the street and the corner. I think if you live there, you can somewhat get a feel for it, and a mere idea is probably okay. But then if you have guests, people visiting, it could be confusing, and so that's my main concern in agreeing with, is the fence in the right of way, and because it's in the right of way, it does affect the sight lines, and so that's kind of my feeling on the issue.
You recused yourself, okay. Well, in consideration of a petition for administrative review, the petitioner yourself, Mr. Rosenzweig, has the burden of proof and persuasion that the constructed fence is not in the city's right-of-way. The city of Gaithersburg noted in their testimony that the final approval by the city's inspector was a mistake in December of 2014, as that the construction of the fence was not in accordance with the submitted plans or the city code. It's also noted in the city's testimony that the constructed fence along Reading Ridge skews out to 2.5 feet and is located in the city's right-of-way. So I would say that we would need to deny the administrative review application because proof has not been provided that the fence section in question is not located within the city's public right-of-way. And I agree that there was a lot of discussion on this, and a lot of maps, and a lot of discussion. A lot of discussion there. All right, so I'm going to ask for the board to call for a motion of the administrative review. We can either approve or deny. If we approve, say that the city erred in issuing the notice to correct the violation, or deny the administrative review, which would say that the city was correct in issuing the notice to correct violations.
I'll make a motion that we vote, and I'll put forth a proposal that we vote on the denial of the administrative review.
Do I have a second for that?
Second.
Okay, I'll call for the vote. All those in favor?
Aye.
Opposed? Okay, the motion passes 4-0. All right.
Do
Is
we
there-
want the board to provide some additional information on exhibits that they rely on for a resolution?
or is the first question is the board directing staff to prepare a written decision incorporating its deliberations?
Yes.
And then the question would be, will the board give additional direction to staff in terms of the exhibits from the record upon which it relies to determine that the fence is in fact located in the right-of-way?
Yes.
So it's just on the record
Yeah.
for all of you to provide some references from the
References
exhibits.
from the exhibits
Yeah.
there? Sure, you mean now? We'll do it right now? Okay, sure.
And I have everything up if we want to pull anything up that you'd like to look at.
Let's see, let me just pull my notes out here. There was that, the map that the city, I think was. So it was part of the pre-hearing statement by City Attorney Lynn Board, Exhibit 30, and then looking at the attachments that was attached to that exhibit, these would have been exhibits, let's see. It was the map that had a lot of lines on it.
Was this from the last meeting?
From the
where
last
we
meeting.
introduced new exhibits?
No, this was the map that the city had used.
Madam
and-
Chair,
Yes,
you may be referring to Exhibit 40 and then Exhibit 41, which is the section of the road that shows the right-of-way.
yes, I am. It's Exhibit 40 and Exhibit 41. And then, Robert, to your point about site distance on the,
I think that's Exhibit F. Let's see. That's the permit. Yeah, it's Exhibit F.
Exhibit F.
Exhibit 9,
Oh, okay, I see.
is that,
For clarity of the record, they
Yeah.
were labeled, they were lettered as petitioners exhibits A through some subsequent letter, but they have been numbered consecutively. And I think that for staff's purposes, it would be helpful to give direction, consistently use the number that's listed on the index.
So to go ahead and, Robert, I need the actual number
number
Which
of that
I think that's
exhibit.
9.
Exhibit 9.
Yes, 9.
Okay. And I can,
Exhibit 9, letter F, under 9.
okay.
Yeah, that one right there.
Okay. I see. All right. Additional exhibits with the map. I think that takes care of it.
So what would typically happen at this point is we would have draft a resolution of denial for the board to review, make their own comments at the next Board of Appeals meeting.
Okay.
And then vote to adopt a resolution. Depending on, I say next meeting. Don't know whether we'll get to finish it by then or not, that remains to be seen. So it would be either April 12th meeting or May, I don't have my calendar with me, whatever the May meeting is after that, but we'll have to. we'll have to be in touch about that. May 10th is the next Board of Appeals meeting after the April 12th meeting.
Okay. Okay.
Do you have everything you need?
Yeah, so,
Okay.
I'm sorry, could you give me those dates again?
Sure. April 12th
Mm-hmm.
and May 10th. Those are the next two meetings.
Okay. Got it.
Do we have any further action on this case before us at this time?
I don't think so.
No. Okay.
Not,
All right. Now I'd like to turn it over to Caroline as you,
Yeah, I just wanted to briefly introduce Jasmine Forbes, who is in the audience. She is a fellow planner who is going to kind of be my new backup for the Board of Appeals on time to time if I'm not here. And this is her first Board of Appeals meeting, so I thought she'd come say hello. And Kirk, who has been here for the last, I don't know, several years, is no longer going to be my backup, although I'm sure he will continue to be
I think
my
I will be
backup.
Jasmine's backup still. So.
He still has all the knowledge to back me up. So I just wanted to introduce Jasmine to all of you.
Hi.
thank you.
Welcome.
Nice
Thank
nice
you.
to meet you. Thank you. Is there anything else before the board this evening?
No, the
Okay.
next meeting is April 12th, and regardless of whether or not we have a resolution on this particular case, we do have other cases that night, so we will definitely be meeting.
Okay. All right, well, can I get a motion to adjourn?
Make a motion, we adjourn the March 8th meeting?
Second? Okay, all right. All those in favor?
Aye.
Aye. This meeting is now closed.